I'd like to call the House Health Committee to order. Will the clerk please take the roll? We'll keep that open until we can get people in. Okay. Okay, we get in? Yeah.
Thank you.
All right. Clerk, please take the roll.
Mr. Chairman, you have 15 members present. You have a quorum.
All right, thank you, and my apologies to everybody out there. We had another committee that we were closing that ran over, and that kind of put us all behind. So do we have members that have personal orders? I think Representative Lynn, you're recognized.
Thank you, Mr. Chairman. Committee members and everybody in the audience, I just found out Representative Kip Capley's having a birthday today. He is 28 years old.
All right. All right, we'll have cake later. And any further? Representative Sherrill, you're recognized.
Thank you, Chairman. We do have Dr. Sibley with us today. We want to welcome her and appreciate you being here today. If you would make her welcome.
Thank you. And I believe we have Dr. Reeves Johnson, who's a family medicine physician. Here he is. He is from Knox County, and he is our doctor of the day. So thank you for being here. All righty. So that brings us to our agenda. That brings up item number 1, House Bill 843 by Chairman Haston. You are recognized. You have a motion and a second.
Thank you, Mr. Chairman. Two of my counties, Perry and Decatur, who are distressed and at-risk counties, both had hospitals to close several years ago. Thankfully, they were both in the process of reopening. This bill simply designates these two hospitals as critical access hospitals, and while also helping to ensure future federal requirements would be met. With that, I'll be glad to answer any questions.
All right. Thank you. Do we have any questions for the sponsor of the bill? All right. Seeing none, we're going to be voting on House Bill 843. Will the clerk please open the vote? All those in favor of House Bill 843, moving on to calendar rules, vote aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Clerk, please take the vote.
Mr. Chairman, you have 17 ayes, 0 nays.
All right. House Bill 843 moves on to calendar and rules.
Thank you, Chairman of the Committee.
All right. Thank you. Okay. That brings us to item number 2, House Bill 498. Chairman Hale, you have a motion and a second. And let's see. We have an amendment?
Yes.
We have amendment 004414. Is that correct?
That's correct, sir.
Okay. Can I get a motion? We have a motion and a second. If there's no objection, let's go ahead and get the amendment put on. All those in favor say aye. Aye. Opposed? Ayes have it. We're back on the bill as amended. You're recognized.
All right. House Bill 498 reestablishes a task force to examine provider reimbursement rates and provide recommendations to state agencies that contract with providers in Tennessee. This legislation mirrors legislation from a few years ago, seeks to continue the good work done by the previous task force. The members of the task force will be appointed by the Speaker and Lieutenant Governor and will serve without pay.
All right. Thank you. Do we have any questions for the sponsor of the bill? All right. Seeing none, we are ready to vote. Clerk, will you open up the vote? Okay. All those in favor of House Bill 498 as amended going to calendar and rules, vote yes. All the opposed, vote no. Has every member voted? Does any member wish to change their vote? Clerk, please take the vote.
Mr. Chairman, you have 19 ayes, 0 nays.
House Bill 498 passes and moves on to calendar and rules. All right, thank you. And I believe you are carrying item number 3. Let me get my notes together here. You got them. You have a motion and a second on House Bill 133. And let's see. We do have an amendment, drafting code 4235. Is that correct?
No, sir, we're not taking up the amendment.
Not taking up the amendment. Okay.
Well, it's a subcommittee amendment.
Mm,
I mean,
So-
it's not standard for him to say we're not taking a subcommittee.
Is this not? This is the amendment we adopted out of subcommittee.
That's the previous amendment. Okay, yes,
So we are,
Yes.
this is the one we're taking up.
yes.
Yes, okay.
Yeah,
We need to put
that's
that on.
right. That's
Yes.
right.
Okay.
Make sure we're
So I need
right.
a motion and a
Yes,
second. on
4235.
4235, okay. So all those in favor of 4235, say aye. Aye. Opposed? Ayes have it. Now we're in the position we think
Now we're
in.
good. Thank you, Chairman.
Okay, you are
Committee.
recognized.
Yes. And just to clarify, there had been some discussion about another amendment. That amendment we did not take up. And so I'm honored to carry this bill for our dear friend, Representative Raper, during his recovery. House Bill 133 simply extends the already existing pilot program for residential facilities for people with developmental or physical disabilities. Pilot program already exists for a facility in both Western and Middle Grand Divisions, and this would extend it to the Eastern Grand Division. It would be located in Representative Raper's district. Real Life Village is a nonprofit organization in Bradley County that will spearhead the program off of the Westmore Church of God campus. And I was glad to be able to visit with the pastor and gentleman that'll kind of be overseeing this, and had a very good conversation with them today. So I'll renew my motion.
All right. For clarification, we had somebody signed up to testify, but I think they were going to testify against the amendment we did not adopt.
That's
But
correct.
are y'all, they're okay now? Okay. So is there any further questions for the sponsor of the bill? All right, seeing none. All right, clerk, can you open the vote? Okay, we're voting for House Bill 133 to move on to calendar and rules. All those in favor vote aye, all those opposed vote no. Has everybody voted? Does any member wish to change their vote? Clerk, can you please take the vote?
Mr. Chairman, 18 ayes, 0 nays.
All right, thank you. House Bill 133 moves on to calendar and rules.
Thank you, Committee and Chair.
Thank you. All right. All right, that brings us to item number 4. House Bill 717 by Representative Jones. You are recognized.
Thank you, Mr. Chairman. Do I have a motion? Did I have a motion?
You had a motion
Okay.
second. Yeah, you're recognized.
I am honored to sponsor House Bill 717, the Caring for Caregivers Act. This legislation was brought to me by a young man in my area, and I was personally moved by the story as he told about his grandfather's battle with Alzheimer's disease. He told me of how his grandmother had promised to care for him in the home that he had built, and how that it had become not only a burden on her physically, but also on her identity, as it taking care of him had consumed her everyday life. But she was, however, dedicated to the promise, and she continued to keep him in the home. But what we've learned about these across the state, as we've listened to these stories, there's so many, just like this story, all across the state. And the caregivers are losing $36,000 in wages annually and expenses to on the caregiving. This legislation seeks to serve as a foundation for approximately 360,000 caregivers across the state, people who, just like Mrs. Fox, by establishing a 3-year pilot program within the Department of Disability and Aging. It will provide $6,000 of financial grant to family of caregivers of individuals diagnosed with Alzheimer's disease and related dementias. Research has shown that by providing grants like these, it not only helps reduce the burden on the caregivers, but it also helps the caregivers provide better quality of care to the loved ones they serve. Such states as Georgia, Missouri, and South Carolina have already passed programs like this to cover the out-of-pocket expenses of taxpayers simply by using this program. I humbly ask for your support of House Bill 717 and demonstrating our commitment to improving the lives of caregivers and the loved ones they serve. With
Right.
that, I stand ready for questions.
All right, thank you for that explanation. Do we have any questions for the sponsor of the bill? All right. Mayor Hicks, you recognize?
Thank you, Mr. Chairman, and Representative Jones, I thank you for bringing this bill. It's important, and I think the young man that actually worked on this bill and it's basically gave it to you and worked extremely hard and watched his grandfather have a hard time and understands the issue. Just a great young man is in our audience today. And Jackson Nolan, please stand up, sir. And we appreciate you and all your hard work on this, along with Representative Jones. It's an extremely important bill. And there's nothing any more important than taking care of those that's having a hard time to take care of themselves. So we thank you for that. And thank you, Jackson. Appreciate it.
You recognize?
I would just echo what you said, that he has done a fabulous job, and to see someone his age taking such interest in taking care of our older population and working this bill with me has been just the joy to work with him.
All right, thank you. Any further questions for the sponsor of the bill? All right, we are ready to vote. So clerk, will you please open the vote? All those in favor of House Bill 717, moving on to government operations, vote aye. All those opposed, vote no. Has every member voted? Does any member wish to change their vote? Clerk, please take the vote.
Mr. Chairman, 20 ayes, 0 nays.
All right, House Bill 717 passes and moves on to government operations.
Thank you, Mr. Chairman and committee.
Thank you. All right. That brings us to item number 5. You have a motion and a second. And let's see, is there an amendment?
Yes, sir. There's an amendment that writes the bill.
Okay, let me find here. 5099.
Yes, sir.
Okay, we have a motion and a second. If there's no objection, let's go ahead and get the bill in proper form. All those in favor say aye. Aye. Opposed? Ayes have it. We're back on the bills amended. You're recognized.
Thank you, Mr. Chair. Committee, it's very good to be with y'all today. I have a bill in all reality, it's just a very simple bill. It says that if insurance is going to provide insurance to a patient that brings transition surgeries and treatments and therapies, then they also need to provide the same insurance for detransitioning. Mr. Chair, we have somebody who signed up to speak about this, who's lived in this world and experienced both sides of the issue. And would you like for him to come on up now?
Thank you. We have 2 people that are here to testify, 1 for and 1 against. Does it matter which order?
The ones that don't like it, let's start with them.
Without objection, we'll go out of session. I have them in order here on my list here. So Adam Shoup. Nine. Thank you, sir. And for the record, just state your name and who you're with, and you will have 3 minutes.
Sure. Thank you, Chairman. My name is Adam Shoup. I'm a resident of Davidson County. I'm in House District 50, and I'm testifying today in opposition to HB 754 as the father of an adult trans child. This General Assembly has repeatedly demonstrated its intent to legislatively erase transgender people alongside a barrage of legislation to limit access to healthcare, including the statewide ban on gender-affirming care for minors. 2 years ago, when that bill was debated, House Speaker Lambert said it was just about youth. Quote, "Love these children, support these children, get them through adolescence, just get them to 18, and then they can make whatever decision that they want to." Now with HB 754, you're considering intruding on the patient privacy of adults seeking gender-affirming care. Although the patient names and individually identifiable health information cannot be collected, the Department of Health would not only collect but publicly report the following: age, sex, state and county of residence of patients, confidential health information including diagnoses, dates of services, and prescribed pharmaceutical or surgical care, as well as the name, contact information, and specialty of individual providers. It would not be difficult to identify patients with all of this information or to target and harass providers, particularly in smaller communities where there are limited numbers of physicians who provide this type of healthcare. This bill also promotes dubious treatment for detransition, such as conversion therapy. A 2019 study published in the Journal of the American Medical Association Psychiatry found that trans people who received conversion therapy were more than twice as likely to have attempted suicide and 1.5 times as likely to experience severe psychological distress compared to trans people who underwent other kinds of therapy. This is why last September, Kentucky became one of 28 states to ban the practice, which both the American Psychological Association and the American Counseling Association have called harmful and unethical for providers to engage in. We've already seen from the Attorney General's investigation of Vanderbilt Medical that surveilling trans people because of the care they choose to receive does actual harm. After the news of the Vanderbilt investigation was made public, many patients suffered from suicidal ideation, severe depression, and intense anxiety. This bill is derived from model legislation promoted by a group that has called gender-affirming care a euphemism for biology-denying interventions. Everybody's journey with gender identity and expression is unique to them. I understand that some people may simply determine that transition is not right for them, and that should be helped too. But political detransitioners have determined their lived experiences are applicable to everyone else, and that they must prevent transition for everybody else and testify against trans people like my child. I urge this committee to vote against this bill, which further stigmatizes trans people, endangers patient privacy, and puts a target on the back of providers. Thank you.
Thank you for your testimony. Do we have any questions for our witness? All right. Seeing none, thank you so much for coming and appreciate your time. Appreciate you being with us. We have a Winter Breedlove. And tell us your name and who you're with, and you will have 3 minutes. Thank you.
Legally, my name's still Winter Breedlove. My name's JD. In 2025, I reached out to Vanderbilt Vivid Health seeking therapy services as a gender transitioning sexual trauma survivor. I wanted to investigate the current loopholes in our system and see if anything had changed. Instead of being connected with appropriate care, I was routed to a general answering services and ultimately redirected back to the switchboard without any meaningful assistance. This experience, occurring years after my initial consultation in 2019, underscores the persistent gaps in patient care. Individuals like myself are left without clear pathways to appropriate treatment, whether seeking therapy or detransitioner health care. The initial communication I received from Vanderbilt was consistently framed within an affirmation model that failed to take into account my lived experience as a sexual trauma survivor. Despite fully disclosing my trauma history to both the psychologist and physician, I was told that my medical transition was the most realistic path forward. My doctor even documented that I was not in a good emotional state, that I struggled with anxiety, and I demonstrated confusion in the decision-making process. But rather than addressing these concerns, the focus remained entirely on my dysphoria. My mental health issues were acknowledged in the doctor's notes, but they were not addressed in a diagnostic assessment. Even Vanderbilt's own plastic surgeon later told me that my concerns about receiving adequate mental health care were valid. Yet for an entire year, this issue was allowed to fester without being addressed. House Bill 754 would help prevent this from happening to others by ensuring that mental health care is addressed on the front end rather than being sidelined in favor of an affirmation-first approach. Additionally, as a detransitioner, I now face significant challenges accessing corrective care. My recent experience at McCary Medical Center shows how the system continues to fail people like me. My healthcare was tracked under the vague code of transgender undefined. This improper coding not only misrepresents my current needs, but also creates additional barriers to receiving medically necessary care. Many detransitioners face similar struggles because there are no specific healthcare codes for our situation. Without the codes enshrined in Bill 754, insurance providers and healthcare systems have no framework to offer us the care that we need. As Jamie Reed, a whistleblower at the St. Louis Gender Clinic, said, "We are building the plane before we are flying it." And that's exactly what happened to me and many others. Now is the time to ground the process in thoughtful, comprehensive care that recognizes the full complexity of underlying comorbidities for sexual trauma survivors like myself, and one that does not merely leave people like me sifting through the wreckage. Thank you.
Thank you, and appreciate your testimony. Do we have questions for the witness? All right, seeing none, thank you. I do appreciate those that came and testified. Appreciate your courage. Get up before us, so thank you for that. So without objection, we will go back into session. Chairman Faison, you are recognized.
Thank you, Mr. Chair. Committee, I've had the privilege of sitting down and spending some time with JD and other individuals who have wrestled with gender dysphoria, who have started the transition, and at some point along the way thought, you know what, I don't know if this is the path forward that I want to continue. And undoubtedly, every single person who sat in my office or I've talked to on the phone or met that has started this, they say there's this built-in group of cheerleaders. There's this built-in sea of people who will love you and affirm you and come behind you and make you think that you're the very best person in the world for pursuing the avenue and he used the word affirming, this avenue of changing your gender. But every single one that has talked to me finds out that they're alone if they question what they were doing and think, you know what, I might have went too far. I want to stop this trajectory. I want to turn around. I want to address the father to the committee that we are not forcing anybody to go through transition. It's not the intent. I would not vote for a bill that would force somebody to do that. But what I am trying to do is create a framework that sea and mountain of people who joined them in affirming that portion of their life that they were moving forward with transition isn't completely gone away from them when they think I've gone too far and I want to turn around and there's nobody there. I spent time with JD and hearing him tell how horrible it was to find anybody to talk to. Finally, some people sent him out to California it was what he thought was a transition clinic, and it was not. It was a massive bully fest on him. He ended up being stabbed and treated terribly bad, and he's still not over it. And still to this day, he's struggling to find anyone who's willing to say, we hear that it's not reality for you and you need help. And committee, what I'm asking is if an insurance company is willing to pay for you to go through the therapy and medical portions of whatever it takes for you to pursue a transition, that insurance company needs to sell you the same insurance to come back off on the other side if you change your mind. That and speaking of the information that we're gathering, committee, I believe it's important. We gather, and you can ask the chairman of your committee, we keep records on all sorts of things when it comes to the medical field in compliance with HIPAA law. We don't know specifics about certain people or their names, but we understand whether anything that has to do with your body, we keep records on it. This is, if we're honest with each other, this is kind of a new phenomenon in the last decade of 20 years of people doing gender transition surgeries. It's really exploded. We need to make sure we're seeing so people 20, 30 years from now can see that we've recorded history of what's going on, not the person, but the medical conditions and the things that happened before, the things that happened during, the things that happen after. That's why this portion's in the bill.
All right, thank you. Questions for the sponsor? Representative Mitchell, you're recognized.
Thank you, Mr. Chairman. Is this an insurance mandate?
You're recognized.
Not in the terms of us telling what they have to cover. It's just a mandate of saying, if you provide transition surgery and you sell transition surgery, then you're going to sell insurance, then you're going to sell detransition insurance as well.
You're recognized.
So it's a mandate. It's kind of like we need to amend this bill. Like most health insurance plans don't cover the cost of reversing a vasectomy. Kind of down the same lines, somebody made a decision about their body, and then now, something's changed either in their life, their mental health, marital status. And, so would you be in favor of us mandating that mandate as well?
You're recognized.
Thank you, Mr. Chair. The gentleman from Davidson County, if you think that's an important bill, I would encourage you to file it, write it, bring it next year, and I'll look at it and I might just support you.
You're recognized.
Yeah, but see, I'm just trying to get to the, other than poll numbers, I'm still trying to figure out why we're discussing these things that should be between a doctor and a patient. I don't see it as my role up here to determine what's the best medical next steps for someone and it sounds like it could be medical, psychological, mental health questions in line. And, I see maybe one guy up here that may be qualified to make decisions like that, but I don't see myself in the position. But I have seen in this state where, unfortunately, I know one doctor all too well that her husband, and her 3 children, lives were threatened because of legislation like this, and they now live in the Northeast, away from the hate. So, we're needing medical professionals in this state more and more, but we seem to keep finding ways to push them across state lines. And this is just another piece of legislation that's doing that. Thank you.
You're recognized.
Thank you, Mr. Chair. People that want to do transition are feeling the hate from the medical community, from doctors, from that whole entire community. So if you want to say there's hate to share first. Secondly, you talked about what the doctor and the patient should be able to talk about. Unfortunately, we live in a society that insurance really dictates more of what happens with the patient than what the doctor. And even the ones that disagree with me would appreciate the fact that we keep insurances out of deciding what happens. So this is just saying, hey, at least allow the conversation to happen between the doctor and the patient. Right now, if there's no insurance for it, they can't even have the conversation. So we're telling the insurance company, at least set that up. So it's a possibility.
Again,
Representative Mitchell.
Thank you, Mr. Chair. And thank you again for admitting it's a mandate on insurance.
Thank you. Chairman Kumar.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, also. It's a matter of fairness in the sense that if a person has insurance, they paid for it, and this is a covered service, they were able to make use of that service. And then as the situation changes, as far as detransition is concerned, the same amenities should be available if they are still carrying the same insurance and paying for it. And this should also be a covered service. So it's not that insurance has a right to provide one-way street and there is no coming back from it because insurance controls it. No, it's difficult to afford. Without that, it seems really very logical and reasonable to me. Thank you for bringing it.
Good.
Thank you, Dr. Kumar.
All right. Chairman Clemens?
Yeah, thank you, Mr. Chairman, and I appreciate the insurance mandates. I mean, serving in a state where insurance industry basically runs the Department of Commerce and Insurance, I love to see these types of things, and I'm happy to work with you on these. And I also am glad that this body's formally recognizing gender dysphoria as a clinical diagnosis. That's even included in the DSM. There wasn't too long ago that I was sat on this committee and said the words gender dysphoria and had people laughing at me and accusing me of making something up. So I am glad to see we're making progress in that regard. I do have one question, and it's the same question I asked you in the subcommittee last week, and it's an issue of vagueness that I perceive in the bill that I need clarification on. In 68-1-2502, the right to effective care, this targets or includes gender clinics who receive state funds. And so are we talking about gender clinics who receive state funds and also happen to provide gender transition services? Or are we talking about gender clinics who receive state funds specifically for gender transition services? There's a big distinction there, and I think we need to get that clarified.
You're recognized.
Thank you, Mr. Chair. From my understanding of the bill, this is clinics who also provide. Any clinic that provides, regardless of what they do, if they provide this in part of their care, and they accept the insurance for transition surgeries or care, then they also will have to accept the insurance that would allow for detransition as well, because it's the same insurance.
Chairman Clemens?
Mr. Chairman, we might need to go out of session to hear from legal because the plain language of this bill implies something contrary to what the sponsor said, that uses funds provided by this state to directly or indirectly pay for gender transition procedures. And that's not exactly what was just represented. Can we go out of session to get clarification from legal?
Okay, without objection, we will go out of session. And, okay, we'll have legal.
Heather Asbell, Legal Services. The definition of gender clinic is defined in 68-1-2501 in the bill, and it says gender clinic means a healthcare entity licensed under this title that provides or prescribes gender transition procedures. Does that answer your question, Chairman Clemens?
Chairman Clemens, you're recognized.
So does that mean that the language in the bill includes facilities? Because some of those facilities also provide counseling that don't go through those procedures, correct?
That would be a better question for maybe the department. I don't know for certain. Gender clinics also provide counseling services as well.
Okay. And does legal know if any state funds are used to pay for gender transition services? I was under the impression that we're not.
I am not aware but that might be more of a better question for maybe fiscal or the Department of Health to answer whether or not funds are used by the state to pay for gender transition procedures.
Okay, because your first answer to my question implied that gender clinics that use funds provided by this state for gender transitions. But I don't know that our state allows state funds to be used for gender transitions. So this is an issue that requires serious clarification, and this vagueness is going to create issues down the road if this is enacted into law. Do you have any response to that or disagreement with that legally?
Looking at the fiscal memo for this for this bill. It says the Division of TennCare's managed care organizations do not provide coverage for gender transition procedures. Therefore, there'll be no fiscal impact to the TennCare program or Cover Kids program. Additionally, the fiscal memo says the plans under the state group insurance program do not cover gender transition procedures. Therefore, there are no impact to the Division of Benefits Administration. And then it also says gender detransition procedures are not broadly covered under the state's benchmark health plan.
So then there is no gender clinic in the state of Tennessee that would be subject to this this legislation, correct?
I can't speak to that for certain. That would be more up to a court to decide if, I can't say for certain. But I can,
You want to go back into session? I'm done.
Okay.
Hopefully.
Without objection, we'll go back into session. Chairman Faison.
Thank you, Mr. Chair. This goes to private insurances as well, and what future would take place with what the state of Tennessee would cover, not just Tennessee insurance. Goes to private insurance as well.
Chairman Clemens.
Yeah, I mean, but what you heard is the source of my concern here, the undue vagueness of this legislation. If the state of Tennessee doesn't provide funds for the purpose of gender transition services to any gender clinic in the state, then this provision that says this affects gender clinics. I'm talking about targeting the gender clinics, not the insurance. These gender clinics, so are none of them subject to this litigation where care is provided? Because none of them receive state funds.
You recognize.
Thank you, Mr. Chair. This is for private insurance as well. We're covering everything, whether it's state insurance or private insurance. If you're a clinic in Tennessee and you do anything with transition surgeries or gender care, that insurance that's covering that in your clinic, it's also going to cover it for detransition.
Okay, Mr. Chairman.
You recognize.
Thank you. Let's put aside insurance, focusing on the gender clinics. This section, sub C of this 2502, page 2, says a gender clinic that uses funds provided by this state to directly or indirectly provide or pay for gender transition procedures must, as a condition of receiving such funds, agree to provide or pay for the performance of detransition procedures. It seems to me, based on what legal has said, that C doesn't belong in this legislation because there is no gender clinic who receives state funds for gender transition services. Does that make sense?
You recognize.
Thank you, Mr. Chair. There are plenty of places like Vanderbilt who receive state funds. Whether they're doing it specifically for that or not is immaterial. And we don't know what's coming forward in the next years in Tennessee. So I want to put on there, if you're taking it, state funds, not state funds, private funds, public funds, that you have to take insurance for both sides.
Thank you, Mr. Chair. I understand that. But what I'm getting at is the clarification of this provision. The legal has said that these are gender clinics which provide those services that receive state funds. That's what this says. But none of them receive state funds for that purpose. So I'm trying to get to the bottom of why is this in here? And if it's purposefully in here just for another clinic that's not a gender clinic, which Vanderbilt's a large hospital, that's not just a gender clinic, it may have one within it that doesn't receive any state funds for these purposes. So just because it receives state funds for an OB department or something like that can't be used for gender transition services, it's coming under the guise of this legislation. That makes no sense. So that's what I'm trying to get to the bottom of here.
Thank you, Mr. Chair. We want to make sure if you're taking state funds for any reason and you're doing stuff with gender care, that we keep the data from that, not the individual person, but to keep the data from it, number one. Then number two, we will, so if you take private funds or public funds, that you allow for treatment on both sides of that. We don't know what's going to happen, setting up a frame for it if something does happen in the future.
Thank you, Mr. Chair. I think we're missing the ball here. Thanks.
Representative Hammer.
Thank you, Mr. Chair. The question to sponsors, try to get to your intent. Does this bill require any mental health providers to register and report as a gender clinic?
You recognize.
No, that's not the intent of this legislation.
Yeah. All right. Representative Travis.
Thank you, Mr. Chairman. Leader Faison, it's good to see you again. It shows on the other physical impact up here that the treatment's being provided for the plans that do not currently offer these benefits. That is not what this bill's talking about. Where if a company does not offer the services, then they do not have to cover this, correct?
You're recognized.
That's correct, Chairman.
Okay. So now we're going back to one more thing that I've seen that I don't know what insurance companies do cover this procedure. But when we sit there and you mandate that they're going to have to cover the opposite and get them back to where they were, then I think I see insurance companies that's going to come out and put an exclusion on all their health plans where this will not be covered, period, at all. But this is not a mandate. So we're not going to make insurance cover it. So if an insurance company comes out and says, we're going to put an exclusion and we're not going to cover this procedure, then that's their choice, correct?
You recognize?
Thank you, Mr. Chair. That is correct. Yes, sir.
Thank you, sir.
All right, thank you. Any further questions? Seeing none, clerk, we are ready to vote. All those in favor of House Bill 754, moving on to Finance, Ways and Means, vote yes. All those opposed, vote no. Has every member voted? Does any member wish to change their vote? Having problems, okay. Ian? Okay, all right, clerk, please take the vote.
Mr. Chairman, 18 ayes, 5 nays.
All right, House Bill 754 moves on to Finance, Ways and Means.
Thank you, committee.
Okay, that brings us to item number 6. House Joint Resolution 28 by Chairman Bolso. Do you have a motion? Do I hear a second? Okay, you have a motion and a second. You are recognized, and there is an amendment. Is that correct?
Yes, Mr. Chairman, it is.
Drafting code 4774.
Yes, that is it.
Okay, if there's no objection, let's go ahead and apply the amendment. All those in favor say aye. Aye. Opposed? Ayes have it. We are back on the bills amended. You're recognized.
Thank you, Mr. Chairman. Good afternoon, members. As I mentioned in subcommittee last week, this proposed constitutional amendment raises a single question. Should the people of Tennessee have the right to decide whether their government can force them to undergo a medical treatment? That is a question that, if adopted, this amendment would put before our citizens at the next gubernatorial election in 2030. As all of you know, we have got our Tennessee state constitution that actually begins with a Declaration of Rights. And Section 1, Article 8, Article 1, Section 8 of the Tennessee Constitution has what functions as a due process clause. It gives every person the right to life, liberty, or property, but by the judgment of peers, or what's called the law of the land. And over the years, the courts have interpreted our law of the land provision as being a substantive equivalent of the due process clause in the U.S. Constitution, such that right now we have a liberty interest protected in our Constitution, but there's nothing that specifically deals with this issue of medical freedom. And if, in fact, the people of Tennessee adopt a right to medical freedom, it will be enshrined in our state constitution as an explicit right. And with that, Mr. Chairman, I stand ready for questions.
All right, thank you. And before we have questions, I do believe we have someone here to testify on the bill. There's not. Do we not? Oh, okay. Okay, well, we have questions on the bill then. Any questions for the sponsor of the bill? Chairman Kumar.
Thank you, Mr. Chairman. Thank you, Chairman Bolso. You've been very generous in giving your time to our questions. Kindly, just for the non-lawyers here in the audience, explain what you mean by due process.
You recognize.
Thank you, Mr. Chairman. Yes, I'm happy to. Chairman Kumar, when you look at the 14th Amendment, Section 1 provides that no person shall be deprived of life, liberty, or property without due process of law. And that clause, without due process of law, over the years has been found to have both a procedural component and a substantive component. That is, courts must honor your rights to life, liberty, and property, both procedurally and substantively. And with regard to the substance of it, what it effectively means is that any right that you have in the Constitution is a fundamental right, and the government cannot interfere with that right except under very narrow circumstances. In particular, any law that affects a fundamental right has to be narrowly tailored and has to support what's called a compelling state interest. And over the years, that standard has been applied to cases regarding the right to refuse medical treatment. You'll likely recall back in 1975, for example, we had the case of Karen Ann Quinlan, which I believe came out of Massachusetts. And the issue there was, whether Karen Ann Quinlan could be removed from a respirator because her parents wanted her off of it. And ultimately, our Supreme Court ruled that, yes, when you look at the right to refuse medical treatment that's implicit in the 14th Amendment, that is a fundamental right. And the state can only overcome that by narrowly tailored means to support a compelling state interest. In that particular case, the state could not show that. And so Karen Ann Quinlan was taken off the respirator. The issue came up again in 1990 in another very famous case involving Nancy Cruzan in Missouri, which had to do with removal of nutrition, a feeding tube. And once again, the Supreme Court looked at the substantive component of due process, and it found that in that particular case, once again, that in order to justify continuing to require Nancy Cruzan to obtain nutrition through a feeding tube, the state had to demonstrate by narrowly tailored means a compelling state interest. It could not do so, and therefore, ultimately, the feeding tube was removed. So let's apply those same principles, Chairman Kumar, to this amendment. This amendment states very simply, absent due process of law, the state may not compel a person to undergo medical treatment, even in the case of a declared medical emergency. So if this amendment is adopted, then what happens? It goes as an express constitutional right in our state constitution. And if this body or a political subdivision of the state adopts a law that, for example, would require a medical treatment, let's say the General Assembly passed a law that said everybody has to be vaccinated against a particular kind of disease. If that's challenged, the question for the Tennessee Supreme Court then becomes, is that law narrowly tailored to support a compelling state interest? If the answer is yes, then it's going to be able to stand. But if the answer is no, because of this amendment, it would fall. And that is the essence of what due process means. It means that every right that we have recognized in our Constitution is not absolute. Every one, and Justice Scalia was very clear about this in his concurring opinion in the Cruzan case, every one of our fundamental constitutional rights is conditional. And it's conditioned on due process. And that's what due process means under the law.
Well, thank you. Can due process be overruled in a national emergency?
The short answer, Chairman Kumar, is I would reframe that slightly, because due process can never be overcome. Due process is always required, but in the case of a national emergency, could a court find under due process that a particular treatment is required? And the short answer is yes, because once again, no one can tell you how any court is going to resolve a case in the future, especially on a set of hypothetical facts. But one thing that we can tell you is that the analysis the court is going to use is this. If this body passes a law that infringes upon the right to medical freedom, the court will ask, is that law narrowly tailored to support a compelling state interest? And typically the answer to that question is no. It's a very hard standard to reach. It's called strict scrutiny under the law. But is it possible? Absolutely, it's possible.
You're recognized.
So if this amendment passes and moves on to the next steps, would due process bill still be alive and well?
You're recognized.
Thank you, Mr. Chairman. Absolutely, it would be.
Thank you. And, the other concerns I'm sure that have been brought to you, and just for the record, about a person in a mental health crisis who refuses treatment and they're possibly a threat to themselves or to others, or a person with a serious infectious disease who is confined in a particular environment, whether it's an outbreak of a particular disease in a dormitory or the corrections facilities, not that there's anything similar about them. Those matters, I think you have explained that this amendment will not interfere in steps being taken to protect people during those circumstances.
You're recognized.
Thank you, Mr. Chairman. Yes, that is 100% correct, Chairman Kumar, because we already have in place statutory protections, that is statutory due process, both procedural and substantive, to address those issues. And just to put the point in graphic relief, obviously, the most fundamental right that we all have under our Constitution, both federal and state, is the right to life. Yet, the state, if it finds you guilty of a capital offense, can take away your right to life. And that's obviously happened in the history of our state. So just as with life, any type of liberty or any type of property, a right to medical freedom is also subject to the due process guarantees.
And sorry, the last question, isn't this right already available to us?
You're recognized.
Thank you, Mr. Chairman. An excellent question. And the short answer is yes. When you look at our case law precedent, and let me go back to Cruzen for a second, because that's one case where the U.S. Supreme Court recognized that the right to refuse medical treatment was inherent in the 14th Amendment. Our own state Supreme Court in the Garcia case in 2002, just 12 years later, adopted that analysis in the Cruzen case. So does this right to a certain extent already exist? It does. It's implicit. The beauty of this amendment is it makes it explicit so that it cannot be changed, because right now, obviously, Tennessee Supreme Court can change its precedent. The U.S. Supreme Court can change its precedent. But the question is, should the people of Tennessee get to decide that they hold the right of medical freedom to be so sacrosanct that they want it explicitly provided for in their state constitution?
Thank you. Thank you, Chairman Bose. So you're very learned, and we learned from you. Thank you.
Okay. Representative Mitchell.
Yeah, thank you, Mr. Chairman. Again, we're dealing with a bill that's politicizing life and death. We're bringing politics into saving the lives of people. We discussed this in subcommittee. This is a 120-year precedent set by the United States Supreme Court, Jacobson versus Massachusetts, 1905. Smallpox was killing people in a dramatic number in the state of Massachusetts. They passed a law, everyone had to be vaccinated. The ruling, I think, says it all. Part of the ruling says, the possession and enjoyment of all rights are subject to such reasonable conditions as may be deemed by the governing authority of the country essential to the safety, health, peace, good order, and morals of the community. Even liberty itself, the greatest of all rights, is not unrestricted license to act according to one's own will. It is only freedom from restraint under conditions essential to the equal enjoyment of the same liberty and rights of others. It is in liberty regulated by law. And it goes on to say, a fundamental principle of a social compact, the whole people's covenants with each citizen, and each citizen with the whole people of the community, that shall be governed by certain laws for the common good, and that government is instituted for the common good, for the protection, safety, prosperity, and happiness of the people, and not for the profit, honor, or the private interest of any one man, family, or class of men. And it goes on. I think this is the defining principle. And you agreed with me, if someone came up to you on the street with a deadly weapon, you have the right to defend yourself. Upon the principle of self-defense of paramount necessity, a community has the right to protect itself against an epidemic of disease which threatens the safety and life of its members. It is to be observed that when regulation in question was adopted, smallpox was a deadly disease to that community. So the common good of all should rise above any one person's self-interest. And if someone has an infectious disease, their rights are going far beyond the tip of their nose. They are infecting people around them in the community and killing people. So the take away the rights of a community to defend itself against something like that goes against every moral foundation that our country's been founded upon. Thank you.
You recognize.
Thank you, Mr. Chairman. Representative Mitchell, respectfully, I believe that your statement overstates existing law and actually fails to heed one of the points that Chairman Kumar made. And let me tell you what I mean. Let's just take the law as it stands right now. Let's say that this body passed a law that said every Tennessean has to be vaccinated against smallpox, just as occurred in Jacobson. If someone were to challenge that law and it were to go to the Tennessee Supreme Court, here's the analysis that the Tennessee Supreme Court would use. They'd say, look, this General Assembly's law that requires all Tennesseans to be vaccinated against smallpox affects the right to forego medical treatment. That's what we held as the Tennessee Supreme Court in the Garcia case in 2002, when we adopted the holding of the Cruzen case of the U.S. Supreme Court in 1990. And so the question would be, did the General Assembly, when it passed this law requiring that everyone be vaccinated against smallpox, use a narrowly tailored means to achieve a compelling state interest? That's the question they're going to ask. If this amendment is adopted, the question is not going to be any different. If we enshrine in our state constitution the right to medical freedom, it's still going to be subject to due process of law, both its procedural components and its substantive components. One of those substantive components is this thing called strict scrutiny. Does it, by narrow means, achieve a compelling state interest? So respectfully, I think you're overstating what the law is right now, because what you're suggesting to be the law simply is not the case. And to go back to Chairman Kumar's point, how does this change the law if we adopt this? It simply puts the right to medical freedom explicitly in our state constitution so that it can never be taken away by any court, state or federal. The people put it in there and it's their right.
Representative Mitchell.
Thank you, Mr. Chairman. Is Jacobson still good law?
You recognize.
Thank you, Mr. Chairman. Yes.
Thank you. That's all I need.
Thank you. Representative Clemens, Chairman Clemens.
Yeah, thank you, Mr. Chairman. I appreciate that. And I think the evaluation of the court in response to the Representative Mitchell's question, whether it was narrowly tailored to go to the facts, whether we were just requiring one single shot via syringe, or if we were requiring for instance, to round up all Tennesseans and put them in a camp until they got vaccinated. That's a narrow tailoring. So I'm not sure that your analysis of Representative Mitchell's hypothetical would fail to pass the test. And since we're talking about a compelling state interest here, I mean, I think this bill says shall not compel any person. And so let's look at a micro population. Let's look at a group of prisoners who are incarcerated. This bill would prohibit, if there was an outbreak of anything, smallpox, measles, anything else in a confined prison population, then this says this would prevent us from compelling the vaccination of those inmates. And that is a very unique subgroup. But they would be covered under this constitutional amendment, and we couldn't force them to do it. And I would argue the state has a crucial, essential, and necessary reason to safeguard the public health and safety of those incarcerated individuals who have limited freedoms in their incarcerated role to protect the general health of that population. We cannot require people who are in prison for a minor offense to be sentenced to death simply because of this claim of protecting their freedom. And what I'm trying to do is speak to the breadth of this and how it shouldn't apply, and it doesn't apply. In the court has spoken of this. I think Prince v. Massachusetts even talked about there are different potential harms for different populations. There are vulnerable citizens in the state of Tennessee that are immunocompromised. That's a population that deserves special protection. There's a compelling state interest to protect the general public health and welfare. And I would argue that a simple, let's say, vaccination via syringe is a narrowly tailored approach to addressing that issue and achieving that compelling state interest. Now, there are other ways we could go about it that may not. That's such as gathering people all, up into camps and forcing them to be. That would not be narrowly tailored. So I think that this is concerning on multiple levels. And I think in requiring a person to undergo medical treatment in certain circumstances would certainly satisfy that compelling state interest. Do you not agree with that?
Chairman Bolso.
Thank you, Mr. Chairman. I mean, in short, I do not agree with what you are saying, Chairman Clemens. You started off talking about prisoner cases. And of course, we have many prisoner cases in both the state and the federal court system regarding compulsory medical treatment. That's a special subset of cases. And courts have been very clear that just the mere fact that you're incarcerated doesn't mean you automatically lose your liberty interest in being compelled to undergo a medical treatment. That interest is still there, but once again, it is subject to the due process protections in both our Law of the Land Clause and in the 14th Amendment. So this amendment, if adopted, would do nothing to alter the way prisoners are treated when it comes to compulsory medical procedures. And with regard to the remainder of your comments, I would simply point out, again, that the benefit of this amendment is that it makes explicit in our state constitution that the right of medical freedom is a fundamental right. Tennesseans consider it so important that they want to put it in the Constitution themselves. It's not going to be changing the underlying analysis because every fundamental right, whether it's life, liberty, property, or medical freedom, which is a subset of liberty, every right is still subject to due process, which means that every right is subject to a law passed by this body that's narrowly tailored to protect a compelling state interest. This changes none of that. Really what it does is it gives to the people of Tennessee the right to decide whether they want to enshrine in their own state constitution a provision that says our government cannot force us to undergo a medical treatment. And in my view, the people ought to be given the right to make that decision.
Thank you, Mr. Chairman. The fact that this refers to any person, I'm not sure that prisoners wouldn't fall under this and that wouldn't throw those laws and precedent up in the air. Also, I find it very hypocritical. We're going to talk about protecting medical freedom. Are we going to protect the medical freedom of women in the state of Tennessee? I mean, because we have expressly limited that. So if we're going to talk about protecting medical freedom,
let's go across the board and address the whole thing. And my final question to you is, do you or do you not think that there is a compelling state interest in safeguarding the public health and safety of Tennesseans?
You recognize?
Thank you, Mr. Chairman. Of course, the state has a compelling interest in protecting the public health and safety of all of its citizens.
That's all I got, Mr. Chairman.
All right, thank you. Representative Gillespie.
Thank you, Mr. Chairman. And sponsor, I got here a little late, so I apologize. Chairman Kumar kind of touched on this a little bit, but I just want to play a little scenario game, real life scenario with you and just understand a little bit better here. At the onset of the COVID-19 pandemic, I was working at a continuing care retirement community in Memphis. And fortunately, the organization is about 500 people that live there and roughly 500 people that work there. So a lot of bodies coming in and out of the facility. We did not have any outbreaks, any significant cases until months after. And the reason why that, or at least a large portion, is because of the infectious controls that we put in place at the facility. Now, there is obviously some public health emergencies that have been declared that limited people where they could and could not go. But absent of that, we did limit people's movements around the campus. We required certain procedures to be done. If this goes into effect, how does this affect the scenario that I just laid out?
You recognize?
Thank you, Mr. Chairman. And just to be clear, Representative Gillespie, was the institution you're referring to a private institution?
You recognize?
It's a 501c3, yes, but there are sections of the institution that are Medicaid, Medicare, so there's some oversight there as well.
You recognize?
Thank you, Mr. Chairman. Let me answer it both ways. If you're dealing with a private institution or a private employer, this amendment has no effect because it only acts on the state and its political subdivisions. So in other words, when you actually look at the fundamental rights that all Tennesseans have, those are rights that the state cannot interfere with. Obviously, if you are in a private establishment, the rules are different and governed by different legal analysis. If you're dealing with a public institution, then yes, this amendment will act on the public institution just the way the right to forego medical treatment recognized by both our state and federal Supreme Courts operate.
You recognize?
So just to follow up, what we did, and I hate to indulge the audience there, but I think it's very relevant to the conversation that we're having. Our independent living facilities were just that, independent, not regulated by anyone. And we made the decision to prohibit certain people from leaving independent living and going into assisted or long-term care, or vice versa, more importantly. And if they did, we required certain quarantine and certain procedures to be taken place. That was a requirement that we did. So you're saying we would not be able to do that?
You recognize?
Thank you, Mr. Chairman. No, I'm saying the opposite. I'm saying because you're a private institution, you can do that. Both now and even after this amendment, if adopted, goes into Article 1 of our Constitution.
So the state-funded portion of the facility would also be allowed to do that then as well, because we're talking about federal, state, and local as well as private, all on the same campus.
You recognize?
Thank you, Mr. Chairman. Well, let's make sure we make the accurate distinction. If you're talking about a private institution, a 501c3 corporation, that is a private institution regardless of where it gets funding. It is not subject to the rights that are set out in Article 1, Section 8 of our state constitution, or Section 1 of the 14th Amendment.
Okay. That was not the case with the signage that was put up there. Thank you.
Thank you. Representative Travis.
Thank you, Mr. Chairman. And Chairman, thanks for being here today. I have a question on the vaccinations. This doesn't affect any children vaccinations that we give at the present time for like polio or any of these vaccinations that we're giving our children today? Will it affect that?
You recognize.
Thank you, Mr. Chairman. No, it will not.
All persons.
Thanks for answering the question, but I have people saying that it will. I don't know. Help. Would you clarify that, sir?
You're recognized.
Thank you, Mr. Chairman. Yes, I can help you with that, Representative Travis, because let's take a look at what the law is right now. Okay. The law right now is that you and everyone else in Tennessee has the right to refuse medical treatment. Both our state and our federal Supreme Courts have said you have that right under the 14th Amendment. In the case of our state Supreme Court, under Article 1, Section 8, you've got that right to forego medical treatment. Now that, of course, is subject to the due process analysis because the due process clause exists both in the 14th Amendment and in Article 1, Section 8. When you're dealing with student vaccinations, for example, that is a case, if it's brought to the state Supreme Court right now, that let's just say this body passed a law that said all children in Tennessee have to be vaccinated against smallpox. Their parents have no say in it. We're requiring it. If that law were challenged right now, the Supreme Court of Tennessee would conduct this analysis. They would say, look, we already recognized in Garcia that we've got a fundamental constitutional right to refuse medical treatment. But the question now is this law that was just passed requiring all school children across Tennessee to be vaccinated against smallpox narrowly tailored to support a compelling state interest? And if the answer to that question is yes, then the law stands as constitutional. If it's no, then it falls. This amendment is not going to change the answer to that question. What this amendment does is it enshrines explicitly in our state constitution the existing right to refuse medical treatment so that it cannot be taken away from Tennesseans without their consent by way of a further amendment.
Representative Travis.
Thank you. Thank you for what you just said. This other question I have, let's go to the COVID vaccination that
sure
I did not want to take. But if my employer says, hey, you have to take this vaccination, and I say no. In Tennessee, if we put this in, will that affect the employers of Tennessee?
You recognize.
Thank you, Mr. Chairman. If the employer is private, no, has no effect. If the employer is public, the state of Tennessee, then it's obviously governed by a different set of circumstances.
Okay. Representative McKenzie.
Thank you, Mr. Chair. So just to pull the string on that one, we have several federal entities here. So if the employer is a federal contractor, would that affect them?
You recognize.
Thank you, Mr. Chairman. I think whether a contractor has a contract with the federal government will not affect whether they can or cannot require certain medical treatments by their employees. If it is a private employer, then as I understand the law, Representative McKenzie, that private employer is going to be governed by laws that govern private employers, not by laws that govern state actors.
You recognize.
Yeah, thank you. So I'll more narrowly tailor my question. So we have federal employees, people that work for the Department of Energy, for the Department of Defense. They get a government check, but it's federal, not state. Would this law restrict their office, their local office, from asking for, in this case, COVID, let's pick that out there, a COVID vaccine?
You recognize.
Thank you, Mr. Chairman. I'd have to give that perhaps some further research, Representative McKenzie. My initial reaction is that if you're dealing with the federal government, it's going to be governed by the federal constitution, not by the state, and there's likely precedent that deals with the federal government. So I'd have to frankly do more research to be able to give you an answer to that question.
Yeah, thank you.
You recognize.
Thank you. I appreciate that. So, and then my last question is on the first thing that you pulled the string on, and that is whether someone can refuse polio vaccine or they can refuse it for their children. And this is just probably a pecking order. When I heard you answer the question, you were talking about established law, but wouldn't this being now codified in our Constitution trump all of that? Wouldn't that be the first thing that they go to, because we appeal things up and up and up? But wouldn't that go back to the Constitution, and then this statement would take a greater effect than a law that passed maybe 10 or 15 years ago? Just throwing a number out.
You recognize.
Thank you, Mr. Chairman. Let me make sure I understand the question. Representative McKenzie, if you're asking whether we would pass a law that would require all children to be vaccinated against polio, would this amendment, if enacted, affect that law, the enforceability, the constitutionality of that law? The short answer is no, because as I mentioned in response to Representative Mitchell and Clement's question, existing law constitutionally says you have a right to refuse medical treatment. So the analysis the court's going to use, if we were to pass such a law, would be, is it narrowly tailored to protect a compelling state interest? That is the exact same question that's going to be asked by the court, even if this language regarding medical freedom is put in our state constitution. The difference is that we enshrine the right explicitly in the Constitution, so courts cannot in the future take it away. The people put it there, and only the people can take it away.
Thank you, Mr. Chair.
All right, Chairman Farmer.
Thank you, Mr. Chair. Move previous question.
All right, question has been called. We are ready to vote. Will the clerk please open the vote? All those in favor of moving House Joint Resolution 28 to Finance, Ways and Means, vote aye. Those opposed, vote no. Has every member voted? Does every member wish to change their vote? Okay, will the clerk please take the vote?
Mr. Chairman, 14 ayes, 7 nays, 1 present not voting.
House Joint Resolution 28 moves on to Finance, Ways and Means.
Thank you, Mr. Chairman. Thank you, committee.
It is my deepest apologies to those that were here to testify today on another bill. It was my intent to get to that bill, but obviously that did not happen. We were delayed from another committee, and so we are on a hard stop. So with that, all bills left on the committee will be heard next week's calendar. We are adjourned.